You have exactly 3 seconds. The moment a police officer steps out of their vehicle behind your car, a timer begins counting. They're going to approach your window, illuminate your face with a flashlight, and ask a question that has led more legally armed citizens into legal challenges than almost anything else. Here it is. Do you have any weapons in the vehicle? It sounds like a straightforward inquiry. It sounds like the officer is simply ensuring everyone remains safe. But what I'm about to share with you is something that defense attorneys wish every single client understood before they ever spoke during a traffic stop. That question is not an opportunity for conversation. It is not a request for your complete background. And if you respond to it the way your instincts are telling you to right now, you might as well be providing that officer the tools for your own legal complications. I'm going to give you 5 words, 5 specific words that you need to have prepared before you ever start your car. But before I give them to you, I need you to understand something critical. Because knowing what to say without understanding why those words work is like knowing how to operate a tool without knowing how to use it properly. So stay with me, this is going to take a few minutes, and those few minutes could be the difference between driving home tonight and spending the night explaining yourself to a public defender. Let's start with a scenario, not a theoretical situation, a pattern that occurs thousands of times every year across this country. You are a law-abiding gun owner. You have your concealed carry permit. You've completed the training. You handle your firearm responsibly by every measurable standard. You are the responsible armed citizen. You're driving home from the shooting range. Or maybe you're just running a late errand. You have your pistol secured in the center console or maybe on your hip under your jacket. Suddenly, those emergency lights appear in your rearview mirror. White first, then red and blue. Your stomach drops. You did something minor, a broken tail light, an incomplete stop. You pull over. You lower your window. You place your hands on the wheel. The officer checks your plates, approaches, and asks for your license and registration. You provide it. And then comes the second question, the important one. Do you have any weapons in the vehicle? Now your mind kicks into overdrive. You're an honest person. You believe in transparency. You think if I just explain everything clearly, the officer will see I'm not a threat. So you do what 90% of gun owners do. You open your mouth and try to help. Yes, officer, I have a handgun in my console. I have a concealed carry permit right here. It's not loaded. Well, the magazine is in, but there's no round in the chamber. I was just at the range. I'm a law-abiding citizen. I'm not trying to cause any trouble. Stop right there. I know that feels like the correct response. It feels cooperative. It feels safe. It feels like you're building goodwill. But let me show you exactly what just happened from a legal perspective, because while you were talking, you stepped on multiple legal challenges and you created every single one yourself voluntarily, without a warrant, without a subpoena, without anyone forcing a single word out of you. Let's break it down sentence by sentence. Yes, officer, I have a handgun in my console. You just confirmed the armed half of the equation that matters legally. Before you said that, the officer had reasonable suspicion to stop you for a traffic violation. That's it. Now he has specific, confirmed knowledge that there is a weapon in the vehicle. His authority to control the encounter just expanded. I have a concealed carry permit right here. Did you actually present it with your license? If you forgot it at home, you may have just admitted to carrying without your permit on your person, which is a violation in many states. And is your permit 100% current? Did you move recently and forget to update your address? In some jurisdictions, a permit with an outdated address is technically invalid. You just revealed something you didn't even realize was a problem. It's not loaded. Are you absolutely certain you were at the range? You were handling ammunition. In the stress of this moment, are you completely sure there is no round in the chamber? Because if the officer retrieves that gun and discovers one in there, he now has evidence that you provided false information. Providing false information to a police officer is an offence in itself, often a misdemeanor that can follow you for years and affect your credibility in any future legal proceeding. Well, the magazine is in, but there's no round in the chamber. Now you're getting into challenging legal territory. In several states, having a magazine inserted in a firearm is legally considered loaded, regardless of whether a round is chambered. You may have just described an offense you didn't even know you were committing. You provided the prosecutor his opening line, "I was just at the shooting range." Think about what you actually communicated there. You told the officer you were recently in a high-energy environment. You were recently firing weapons and the gun was recently handled. In the wrong officer's mind, that might translate to subject is energized, has been shooting, and is armed right now. I'm not trying to cause any trouble. This is the one that concerns me every time. It's the statement of a completely innocent person. But in a police report, it often gets rendered as subject was visibly nervous and stated he was not trying to cause trouble, suggesting an awareness that the situation could escalate. You introduced the concept of trouble into a conversation where it didn't exist before you brought it up. Every single extra word you added, everyone was a gift to anyone who might later want to build a case against you. Defense attorneys have a saying that you need to write down right now. You cannot talk your way out of an arrest, but you can absolutely talk your way into one. Here's something that nobody tells gun owners, and it is absolutely critical to understanding why this keeps happening. Your brain, under the stress of a police encounter, is running a fundamentally flawed program. It is telling you that cooperation means talking, that silence means guilt, that the more you explain, the safer you are. Every single one of those instincts is incorrect. Silence is not guilt. Silence is a constitutionally protected right guaranteed by the Fifth Amendment of the United States Constitution. It does not diminish because you have a carry permit. It does not disappear because you got pulled over for a broken tail light. The Constitution doesn't care about the context of your traffic stop. And here's something that genuinely surprises most people when they hear it. Staying silent actually creates a clearer, safer encounter for the officer too. When you start volunteering fragmented, half-remembered, stress-influenced information, you create ambiguity that an officer has to interpret in real time. You introduce new variables into a situation that was simple, minimum words, maximum clarity. That's better for everyone in that car window. But your brain keeps telling you to talk because you've been culturally conditioned to believe that innocent people cooperate and guilty people go silent. And that conditioning is one of the most legally challenging myths in American culture. Innocent people get convicted every year because they talked. The criminal justice system is not a character evaluation. It is a procedural framework, and the framework rewards those who understand it. Now, the 5 words. When a police officer asks, "Do you have any weapons in the vehicle?" Here is exactly what you say. "I don't answer questions." That's it. 5 words. Calm, respectful, firm, and legally sound. Now, I already know what you're thinking. That sounds impolite. That's going to make the officer upset. That makes me look like I'm hiding something. I need you to push past that reaction, because that reaction, that social pressure to be agreeable, is exactly what the system relies on to get you to give up your rights voluntarily. Let me show you why these specific 5 words are a tactical masterpiece compared to every other option you have. First, it is a statement of personal fact, not an act of defiance. You're not challenging the officer's authority. You're not telling him what he can or cannot do. You are stating something neutral about yourself, the same way you'd say, "I don't drink" or "I don't eat red meat." It is a personal policy, stated calmly. It is much harder for an officer to take offense at a quietly stated personal position than at a direct refusal or a confrontational claim. Second, it prevents you from accidentally committing an offense. If you say no and you're actually carrying, you just provided false information to a law enforcement officer. That's an offense in most jurisdictions. If you say yes and start explaining, you've opened the door to everything we just walked through. "I don't answer questions" is neither yes nor no. You have said nothing false. You have given them nothing to work with. Third, that phrasing covers everything that follows. Notice it's not "I don't answer that question." It's "I don't answer questions." The policy applies to the entire encounter. You don't have to re-invoke it for every follow-up. You set the tone for the whole interaction in one sentence. Fourth, and this is the part people always miss, it actually reduces tension in the physical dynamic. When you start talking rapidly about where your gun is, whether it's loaded, how you handle it, the magazine, you are discussing a dangerous weapon while potentially moving your hands that makes officers concerned in ways you can't predict. I don't answer questions delivered with your hands still at 10 and 2. Signals that you are a composed, legally informed individual. It communicates calm, and calm is contagious. But the words are only half of it. Your delivery is the other half. And this is where most people undo everything they just built. Here's the wrong way to say it. Eyes rolling, smirk on your face. Yeah, I don't answer questions, man. That is how you end up in handcuffs. That is defiance. That is a power struggle. And it gives the officer both the justification and the motivation to make the rest of this encounter very difficult. Here is the right way. Hands at 10 and 2, visible at all times. Eyes forward or making calm, natural eye contact. Not darting, not avoiding, just composed. Voice neutral, not cold, not overly friendly, not apologetic. The same tone you'd use to tell someone what time it is. I don't answer questions, officer. That's it. The word officer at the end is not insignificant. It communicates respect without submission. It signals that this is a professional interaction, not a confrontation. And your body language has to match. An officer conducting a traffic stop is trained to read hands, eyes, breathing, and micro-expressions. They are building a narrative about you in real time. If your body is broadcasting fear and evasion while your mouth is saying the right words, those two signals create a contradiction that an experienced officer will absolutely notice. So here's the full picture. Hands visible at 10 and 2 at all times. If you need to reach for your registration, you announce it first. My registration is in my glove box. I'm going to reach for it with my right hand. Then you move slowly and deliberately, breathing even. This one is harder under stress, but it matters. Slow your breath deliberately. It lowers your heart rate, steadies your voice, and signals composure to the person watching you. And comply with every lawful order. If the officer asks you to step out of the vehicle, you do so immediately and calmly without argument. Comply with lawful orders and exercise constitutional rights are not opposites. They exist in the same space. Now let's talk about what happens after you say the 5 words, because this is where most people falter. They manage to say the right thing and then the officer pushes back and they give in because they weren't prepared for what came next. Here are the 3 most common responses you'll get and exactly how to handle each one. The officer says, "Look, I'm just asking for everyone's safety. I need to know if there's a gun in the car so nobody gets hurt. This sounds completely reasonable. It's designed to." It pulls at your instinct to be helpful and cooperative. Your response is to acknowledge the concern without yielding the position. "I understand that, officer. My hands are on the wheel. I'm not reaching for anything. I just don't answer questions. You haven't been impolite. You haven't escalated anything. You acknowledged his concern and you showed him with your actions, hands visible, body still, that you are not a threat. But you held the line on your words." The officer says, "If you have nothing to hide, why won't you just answer the question?" This is one of the most common psychological pressure tactics used during roadside encounters, and you need to understand it clearly. This question has no winning answer if you try to answer it directly, because the moment you start explaining why you're not answering, you've re-entered the conversation on his terms. "With respect, officer, that's my personal policy. I don't answer questions. You do not need to justify your innocence. You do not need to explain the Fifth Amendment to him. You simply hold your policy. Calm, steady, done." The officer says, "Are you refusing to cooperate with my investigation?" This is a high-pressure tactic, and it is designed to make you feel like someone doing something wrong. It wants you to panic and say, no, I'll tell you everything." There is a critical legal difference between compliance and cooperation that you need to have ready. "Officer, I am complying with all of your lawful orders. I have my hands where you can see them. I provided my license and registration. I'm following your instructions. I just don't answer questions." There is a difference between complying and answering questions. When you say that, the officer knows they are dealing with someone who understands the system. Most of the time, they will stop the pressure tactic. They'll write your citation and you'll go on your way. Now, let's address something that I know is on your mind because it's the most common question I get on this topic. What about duty to inform states? Don't I have to tell the officer if I'm carrying? Yes. In certain states, absolutely yes. This is a real legal obligation, and I am not telling you to break the law. Let me be completely clear about that. If you are in a duty to inform state and you are carrying a concealed firearm, you are legally required to disclose that to a law enforcement officer upon contact. But here is what most gun owners don't understand about duty to inform laws. They are extraordinarily narrow in scope. They tell you what to disclose. They do not tell you how much to say. They do not obligate you to answer every follow-up question that flows from that disclosure. States like Ohio, Texas, Michigan, and North Carolina, among others, have these laws. The typical requirement is that you must promptly inform the officer that you are carrying and that you have a valid permit. That's the legal obligation. That's where it ends. Here's exactly how you handle this. As the officer approaches, have your driver's license, registration, and your concealed carry permit ready together. When you hand them over, you say, "Good evening, officer. I'm legally required to inform you that I have a valid concealed carry permit and I am currently armed. How would you like to proceed?" And then you stop talking. Hands back at 10 and 2, mouth closed. Notice what you did there. You satisfied your legal duty completely. You showed him your permit. You informed him you're armed. And then you ended with a question that passes the conversational responsibility back to him, letting him direct the safety logistics of the encounter, which is what he actually needs from you. You didn't tell him where the gun is, how many rounds are loaded, when you last fired it, or where you were coming from. When he asks follow-up questions, where is it? Is there one in the chamber? What model is it? That is when you come back to your 5 words. I've complied with my legal duty to inform you, officer. I don't answer further questions. You have fulfilled the statute. You've done everything the law demands. The duty to inform tells you what to say. It doesn't create an unlimited obligation to become a witness against yourself. Now let's talk about what often comes next. Because if you're carrying, there's a meaningful chance the encounter goes here. Can I search your vehicle? This question feels like a trap. However you answer it, if you say yes, you've just waived your Fourth Amendment rights, and whatever they find, legal or not, is fair game. If you say no, you feel like you're confirming you have something to hide. You don't. You're protecting a constitutional right, and there is a legally clean, respectful way to do it. I do not consent to searches, officer. Not you can't search my car. Not I know my rights. Those phrases invite arguments. I do not consent to searches is a calm, legally operative statement that establishes your position without being confrontational. If the officer keeps pushing, it'll go faster if you just let me look. Or if you have nothing to hide, your response is always identical. I understand. I do not consent to searches. You are not arguing. You are not escalating. You're simply exercising a right that exists regardless of how the officer feels about you exercising it. Now, if the officer decides to search anyway, here's the most important thing I can tell you. Do not physically resist ever. Physical resistance is an offense. It puts you in danger. It gives a prosecutor something to work with that is much harder to challenge than whatever they were originally looking for. What you do instead, you sit completely still. You say clearly for the record, I do not consent to this search. And then you let them proceed. You observe everything you can. The time, the officer's name or badge number, what they touched, what they said, what they found or didn't find. And the moment the encounter is over, you write every single detail down before memory degrades. That refusal, your clearly stated, I do not consent, is not for the officer in that moment. He's going to do what he's going to do. Your refusal is for the judge later. An unlawful search conducted without consent or probable cause is a Fourth Amendment violation. Your attorney can file a motion to suppress whatever they found. Evidence obtained in violation of your constitutional rights can be excluded from trial, but only if you preserve those rights by clearly refusing consent and not physically resisting. You cannot preserve rights you gave away, and you cannot take back consent once you've said it. I want to spend a moment on something that I know some of you are wrestling with right now because it's the most emotionally difficult part of this entire conversation. You're thinking, I'm innocent. I have nothing to hide. Why should I have to act like I'm hiding something? I understand that instinct completely. It comes from integrity. It comes from the genuine belief that transparency should protect you. But here's what experience teaches. The system is not designed to reward your integrity. It is designed to process information. And every piece of information you volunteer is data that enters a system that has absolutely no obligation to interpret it charitably. Prosecutors don't sit down and say, well, he was very forthcoming, so let's give him the benefit of the doubt. They look at what was said and ask how it can be used. Defense attorneys look at what was said and ask how to neutralize it. The less there is to neutralize, the better the outcome for you. And here's something that should give you pause. According to the Innocence Project, in a significant number of wrongful conviction cases eventually overturned with DNA evidence, the innocent person had made some form of incriminating statement to law enforcement, not because they lied, because they talked. Talking under stress produces imprecise, inconsistent, sometimes contradictory statements, and imprecision, inconsistency, and contradiction are exactly what a skilled prosecutor needs to build a narrative. Staying silent is not a betrayal of your integrity. It is the intelligent exercise of a right that the founders built into the highest law of this land because they understood from difficult personal experience how power gets misused when people are pressured to speak. Your silence is not evidence of guilt. It is evidence of wisdom. Let's talk about the absolute worst case scenario because you need to be prepared for it. You can do everything right and still end up in handcuffs. The system is imperfect. Officers make mistakes. Some escalate situations that shouldn't be escalated. And sometimes, even when you have been perfectly polite and perfectly silent, the officer says those words, "Turn around, put your hands behind your back, you're under arrest." Your entire body is going to urge you to challenge this, to explain yourself, to protest your innocence right now. Do not do it. When those words are spoken, the game changes completely, and you have exactly two jobs. Job one is to comply physically. Put your hands behind your back. Do not resist. Do not pull away. Do not tense up. The safer the officer feels during the physical process of arrest, the less likely this situation escalates into something far more serious. This is not surrender. It is strategy. Job two is to become completely quiet. You're in the back of the cruiser. The officer says, "Why did you have that gun?" You say nothing. He says, "You know you're in a lot of trouble." You say nothing, he says, "If you just explain yourself, maybe we can figure this out." You say nothing. There is a powerful myth that if you explain yourself at the station, officers will realize they made a mistake and let you go. That happens in movies. In reality, once you are in custody, anything you say is evidence. The officer is not there to help you. He is building a case. Every friendly word, every detail you offer trying to clear your name becomes material for whoever eventually sits across from you at a prosecution table. There are only 3 words you say after an arrest. "I want my lawyer." Not "I want my lawyer" because not, "I'll tell you what happened after I talked to a lawyer." Just those 3 words stated clearly and unequivocally, because once you say them, the interrogation must stop. If questioning continues after you've requested counsel, anything you say from that point forward can be excluded. But you have to actually say it. Silence alone is not enough at this stage. You must invoke your right to counsel clearly and specifically. And once you're out, once the stop is over, whether it ended with a citation, a search, or an arrest, you write everything down immediately. Every word the officer said, every word you said, the time, the location, the officer's badge number, if you saw it, what was searched, what was found. Studies on eyewitness memory show significant deterioration within 30 minutes of a stressful encounter. Capture what happened while it's intact. That documentation is not excessive caution. It's evidence. It is the foundation your attorney needs if anything needs to be challenged later, and then you call an attorney before you have any further conversation with law enforcement about this incident. Not because you did anything wrong, because you deserve someone in your corner who understands the system. Someone who can look at what happened and tell you clearly whether anything requires attention. Here's the full framework consolidated so you can carry it with you before any traffic stop. Know whether your state has a duty to inform requirement. Know what specifically that law requires you to say. Know exactly where your carry permit is and make sure it's current. The time to learn these things is not when there are blue lights in your rearview mirror. During any traffic stop, hands at 10 and 2, visible at all times, license, registration and carry permit in hand. If you're in a duty to inform state, tone neutral, breathing steady, body calm. When the weapons question comes in a non-duty to inform state, I don't answer questions, officer. 5 words. Hold them. Do not add anything. When the weapons question comes in a duty to inform state, officer, I'm legally required to inform you that I have a valid carry permit and I am currently armed. How would you like to proceed? Then stop talking for all follow-up questions. I've complied with my legal duty to inform, officer. I don't answer further questions when a search is requested. I do not consent to searches. Hold that position regardless of pressure. If they search anyway, do not physically resist. Say clearly that you do not consent. Document everything after. If you're arrested, comply physically. Say nothing. Invoke counsel immediately and specifically. Know the specific requirements and meet them exactly. No more and no less. And the moment a question is asked that goes beyond what the law requires you to answer, you know exactly what to say. Hands visible, tone respectful, words minimal. Those 3 principles applied consistently are your best protection in every police encounter you will ever have. This content is for educational and informational purposes only. It is not legal advice and does not create an attorney-client relationship. Laws regarding firearms, duty to inform, and police encounters vary significantly by state and jurisdiction, and they change. Consult with a qualified criminal defense attorney in your specific state to understand the exact laws that apply to your situation before you need that information.